You're listening to the AfricaMusicLaw.com show, Africa's premier entertainment law show empowering the African artist. And now, your host, attorney, speaker, visionary, game changer, Ms. Uduak.
Hello, AML people, artists, filmmakers, actors, actresses, designers, our entire creative community, and of course, our guests and friends. Welcome to the 39th episode of the AfricaMusicLaw.com show. My name is Uduak, Miss Uduak for short. I am a fashion and entertainment lawyer with the law firm of AB2 Law Group PC located in California, USA. I'm, of course, also a journalist, a blogger, and a podcaster, and the list goes on. The African Music Law Show is a show that is about empowering the African artist, the entire creative industry, but just making sure the African artist and the voice of the African artist is not lost. Our execution is simple. We take on the latest in celebrity legal drama, music business, and industry news, and we provide legal and business commentary and analysis on a lot of those hot topics in pop culture that intersect and at times collide with the law. We also invite our industry experts, our artists, entrepreneurs, and you, the AML listener, to share your insights and experiences to benefit our community of creative talents. You can subscribe on www.africamusiclaw.com to stay updated on when we publish our weekly podcast. If you have an iPhone or iPad, you can find us on iTunes. Please rate us and also leave comments on iTunes so we know how we're doing. If you have an Android, you can find us on Stitcher Radio. You can also follow African Music Law on Twitter on its Twitter handle at African Music Law, and also follow me on my personal Twitter handle at Uduak Law, and that's spelled UDUAK Law. Tweet at me with your comments. I'd love to hear from you. For sponsorship inquiries or to appear on the show as a guest, please email me at africanmusiclaw@gmail.com. Today we have an exciting show, and I'm really honored to have my colleague Richard Bush show up here on African Music Law with a very busy schedule with all the media networks after him to talk to us about his recent win of almost $7.4 million in the case against Marvin, Thicke and Thicke Williams. If you all remember episode number 38, I discussed a little bit about the case and went into a little bit of an analysis on copyright infringement and how it works. A quick synopsis about our guest today. Mr. Bush has successfully represented music clients in numerous trials and appellate court cases. 5 years ago, he represented in the action-styled FBT Productions LLC versus Aftermath Records the plaintiff who discovered, produced, and co-wrote some of the recording artist Eminem's biggest hits. And that was a landmark case in which the United States Court of Appeals for the Ninth Circuit entered judgment in favor of FBT, finding that the agreements between the record label, Universal, and digital download providers like iTunes are licenses, and Eminem's recording agreement entitles him and FBT to 50% of Universal's net receipts for sales by iTunes and others of Eminem's songs. That was a huge case. He also represented Bridgeport Music Inc. and Westbound Records Inc. in a copyright infringement action against Bad Boy Records, the record label owned by Sean Diddy Combs, and Universal Music in a trial that resulted in a $4.4 million jury award in favor of Bridgeport and Westbound, including a finding of willful copyright infringement against the defendants, all rising from the sampling of Bridgeport and Westbound's music in the notorious B.I.G. song Ready to Die. So it's a delight to have him, and he's going to talk about his case and the recent ruling, and he's been so busy all over. And again, I'm happy and really honored that he's here with us today. Finally, when you do listen to the podcast, I start off with discussing an article that I said was LA Times. I actually meant to say LA Weekly. And if you're interested in the article, it's titled Great, Now Blurred Lines Has Ruined the Entire Music Industry. Again, it's by LA Weekly, and the author is Andy Herman. All right, we'll take a quick break. We come back. We go straight into our interview with attorney Richard Bush. We'll be right back.
You're listening to the AfricaMusicLaw.com show, Africa's premier music business and entertainment law show, empowering the African artist.
Back everyone to the AfricanMusicLaw.com show. We've got a wonderful guest here, my colleague Richard Bush, and he just handled a major lawsuit. Everyone is talking about it here in the US and outside of, and I'm so delighted to have him. Richard, how are you?
I'm doing wonderful. I'm happy to be here talking to you.
Thank you so much. So I want us to jump right into it because we have a lot to cover. And I want to look at three different groups: the public, the artists, and our legal community. First of all, I've got a great quote here that is from the LA Times, and I want to cover it because it's quite interesting. They go in on this. And this is the part I'd like you to respond to. It says, but here's the problem. Musicians admit their influences all the time, and they should. There are only so many notes on the scale, only so many tempos and drum patterns, only so many harmonics pleasing to the human ear. Every song, no matter how great or how terrible, builds on the work of past artists. The Bloodlines verdict ignores this, placing for the first time what boils down to feelings under the heading of copyright infringement. And by this logic, the Bob Marley estate can sue pretty much every reggae artist for the past 30 years. The Bo Diddley estate can sue George Michael for Faith, Bow Wow Wow for I Want Candy, and they go on. So could you address that specific issue? Because the public seems to be very frightened about this idea that, hey, with this ruling, now we're basically going to mess up the entire music ecosystem.
I've been walking around and seeing people in public for, 3 or 4 days now. No one seems to be in a panic as far as I can tell. That was the argument that people made during the trial, that a ruling in favor of the Gaye family would ruin the music industry, stifle creativity, civilization as we know it would come to an end. It's nonsense. We had very, very good musicologists, really two of the smartest women that I know. Ingrid Munson, who's the Quincy Jones Professor of African American Music at Harvard University, and Judith Fennell, who broke down these two compositions and showed compositional copying. This was not the copying of a feeling. This was not the copying of a genre. This was not the copying of a style of music. This was the copying of the composition Got to Give It Up by Blurred Lines. The vocal melodies were copied. Note for note, we show that notes were nearly identical. If you listen to it, you hear it. So the bass line, the keyboard, the backup hook, on, the structure. This was the copying of Got to Give It Up. And this idea that this changes the law is silly. What was copyright infringement yesterday or before the verdict is copyright infringement today. Nothing has changed.
Okay, we'll get to that in a minute, but let me address a point that was raised last year by Stevie Wonder when he was asked about this question. He said, look, I've been in a lot of litigation, a lot of lawsuits over time. However, basically the attorney for Marvin Gaye is giving them crappy advice because, of course, I'll be honest, the groove is very similar. He doesn't deny that. He says the groove is very similar, but come on, they're a fan of Marvin Gaye. So, let it be. For everyone saying they're a fan and basically, and including the other side, their opposition sort of made a similar argument. How do you respond to that fan argument?
Well, I'm not going to sit here and badmouth the great Stevie Wonder. I'm certainly not going to sit here and say anything negative about him. I will just note for the record that I think that he and Pharrell work on things together and may be friends. I don't know. I do know that for every Stevie Wonder who has said something like that, there's a Smokey Robinson who came out publicly and said he does think it's the copying of Got to Give It Up and that Robin Thicke should be responsible, should pay. So, this divides people, and different people have different, motivation for saying whatever they want to say. I'm not going to ascribe motives for anything that Stevie Wonder had to say. He's one of the greats, for sure. But, having said that, to say that you're a big fan of Marvin Gaye, and hey, let it be. If you're such a big fan of Marvin Gaye, and you copy Marvin Gaye, and you steal from Marvin Gaye, then you should pay Marvin Gaye. It doesn't seem to me to be a fan to take something that's not yours and then make a lot of money and not give proper credit to the man you sold.
Just generally for the public, there's this idea that if you're paying homage to a great legendary singer, somehow that doesn't translate to infringement. Can you clarify that distinction so the public understands this?
Sure. Absolutely. So there are legal standards that apply in these cases, and the legal standards to be met. So there is what is called the extrinsic test and the intrinsic test. In California, in the Ninth Circuit, to be met for there to be copyright infringement. So you start with the extrinsic test, and what you have to show is that there are compositional similarities. Musicologists come in and point to specific elements of the compositions that they believe are copied. Composition test. It's more of an objective test. So things like homage or genre, generally speaking, will pass that test. Then the second test, once you get past that, is the reasonable ordinary observer. And that's the intrinsic test. And that's basically the question of, would a ordinary observer recognize the taking as coming from the original song? It is only when you can pass both those tests that you reach copyright infringement. So it is not something that is going to open the floodgates because it's not an easy thing.
So let's now get into a little bit more of the procedural history of this case and what the other side is saying and some of the strong words you are using, actually. Starting first with, hey, you're insisting that basically they went and they started this fight and you're finishing it. Opposing counsel is saying, look, we haven't finished. It ain't over till it's over yet. We're going to challenge this on an appellate level. And by the time we're done, he's not even going to see anything. But independent of that, insisting that they filed a lawsuit, isn't it a smart move? Because Pharrell and Robin Thicke were saying that the Marvin Gaye estate was really putting a lot of pressure in terms of refusing to negotiate or settle things and threatening legal action. So they decided to make a preemptive move. So why do you keep emphasizing so much? Well, they started this, so therefore.
Well, I would say this about that. I'm not going to get into and discuss what was discussed before the lawsuit was filed. Those are discussions I don't think are appropriate to be disclosed, but I will say this. We have a far different view of what happened before the lawsuit was filed than they do. And we disagree completely with what they're saying about us being unreasonable and what we supposedly were demanding. We disagree completely with that. Secondly, I would say this, that if there's a question about whether you've copied something, why would you sue? Why would you just not see what happens and defend yourself? And if you're right, then you'll win. To me, it is my opinion that the advice they got was to sue because the Gaye family, they are modest people. They are modest people. They're not Pharrell Williams. They're not Robin Thicke. They're not a big record label with a huge arsenal of money and power behind them. And my personal view is that they sued because they felt like, hey, if we sue, they will just shrink away like little violets and go away back to whatever hole we from and would, in my view, bully us into just going away.
Yeah, you do use that
they
word a lot. They
made that bet, and for them, they bet wrong.
Oh, my apologies about interrupting. Are you done? Go ahead.
I am.
Okay. You do use that word bully a lot, and I was trying to understand why does he keep insisting on bullying? I mean, Marvin Gaye family they have the ability to hire a high-powered attorney like yourself. So where's the bullying coming from?
I don't know that I'm a high-powered attorney, that's for sure.
Oh, you're very, very humble. I mean, your track record is amazing. So.
Thank you.
So I mean, it's so interesting to see the mindset of a very successful lawyer like yourself saying another lawyer with credentials about the same are bullying. So I don't understand it. Make the argument, please, on why you keep insisting that they're bullying you.
No one's bullying me personally. I'm.
Of course not. But but your client. It seems
I'm not
like.
And so they're not bullying me, but. I
don't think they stand a chance if they tried.
What I'd say is that they were attempting to bully Jan Gaye and Nona Gaye and Frankie Gaye. These are people of very modest means, and it is to go through a court case. And there are risks involved. I mean, if you lose, you could be responsible for the other side's attorney's fees. So with all of that, but yet. The amount of money, if Pharrell Williams loses and the record label loses, that's for them. For the Gaye family, had they lost, it could have been ruined. It could have ruined them financially. So they knew that. And so to start this lawsuit and then put the pressure on the Gaye family to say, hey, can we risk this? Can we risk lose? We could lose everything. That, to me, was the strategy, because there was no guarantee that the Gaye family would sue. But when they did that, that put the pressure on them, and they felt like, I think, that the fear of possibly losing would cause the Gaye family just to go away. And I give all the credit in the world to Jan Gaye, who's the matriarch of that family, for doing what she felt was right.
Just define for the general public what we mean by declaratory judgment, because we attorneys just use the word and presume everybody understands that. The move that Robin Thicke and Pharrell Williams made to file this lawsuit first, what does that mean in plain English?
It means what they did was they filed a lawsuit and asked the court to declare, to say that Blurred Lines does not infringe Got to Give It Up. Rather than wait, which is the normal thing, or rather than to see if someone who thinks there is infringement sues, they sued first. And they were asking the court to say, hey, this song does not infringe Got to Give It Up. That's what they asked the court to declare. And so that's what I mean by declaratory judgment.
Another statement you made when we first started this interview was talking about your musicologist, two of them, two females that were awesome. You said, of course, they got the results that we've now heard. However, the other side is saying we are going to challenge on appeal, and the reason the jury should not even have heard the information that the musicologists were presenting to the court. Could you address that part, and then we'll get into the sheet music and what was allowed in and what wasn't?
That the musicologist shouldn't have been allowed to do what?
They said specifically that the credibility and weight of the musicologist was basically questioned and undermined, and that the court, I guess it's going to be the basis for appeal, should not even had really permitted some of the testimony that the musicologists were presenting in court. And even more specifically, they said that your client had gone everywhere to find a musicologist that would testify to what they wanted. They couldn't find one until this too. I'll
have to see what they argue on their appeal. I don't think they have a valid appeal, and I'll mention something else to you. There are procedures during the course of a trial before the jury gets the case to decide, where one side can say, we don't think there's sufficient evidence or evidence to even submit this matter to the jury. And if you don't make that motion, make that request, and it gets stuck with what the jury finds. And in this case, they did not make that motion. They did not make that request. They did not say there's insufficient evidence to go to the jury on copyright infringement. They did not make that. They decided to let this go to the jury without that motion being made. And that's going to be a real problem for them on any appeal.
Very interesting. Let's talk about the jury. There's a sense that maybe the history of a very legendary figure might have affected the jury's decision. What do you think made this jury finally say, look, you're in the right, you get to walk home with $7.4 million for your clients?
I think of the evidence that we put on, the evidence of, as I said, Judith Fennell put on a compelling case of compositional copyright infringement. Ingrid Munson from Harvard did the same. The facts were pretty clear that Mr. Williams and Mr. Thicke, to be kind, did not tell a consistent story of what was in their mind and what they were doing when they created Blurred Lines. And I think all of that was what the jury took into consideration.
Could you just break down, just for our artist community, what should have happened if Pharrell Williams and Robin Thicke needed or wanted to use parts of Gotta Give It Up to create their Blurred Lines music? Right.
One of our experts that also takes her, and she runs a company. She also works for Quincy Jones Music. She also runs her own company. And there are other companies like this. And when new works come out that do use other work, there is a process to the copyright owner of the older work and negotiate a license and ownership in the new work so that royalties will be shared. That's what should have happened in our view in this case. There should have Mr. Camp should have reached out to the Gaye family and should have tried to reach an agreement on a license and what the terms would be.
Okay.
That's what should have happened.
Okay, so now I want to wrap this case up by looking at the damages and then get into your career trajectory for a lot of young entertainment lawyer wannabes that want to walk your path. And so let's talk about damages in general. In a copyright case, we finished. You've got the compensatory damages of 7.4 or about 7.4 million. Now we go into injunctions. Could you just explain that process for our audience to understand and the public at large?
So in a copyright infringement case, a plaintiff is entitled to two sets of damages. Actually, three. One is in the alternative. I'll get into that in a moment. So you are entitled to your actual damages. So making it consistent with this case, actual damages would have been what the license would have been had there been a negotiated license before the song was released. And we had an expert who said that she believed that at minimum the license would have been 50%. 50% of the composition Blurred Lines should have been the Gays. The publishing money that Mr. Williams and Mr. Thicke and Mr. Harris made from Blurred Lines was agreed by the parties to be about $8 million. So the jury, taking that 50% number, awarded $4 million in actual damages, half of the publishing money. In addition to that, in a copyright infringement case, and this is to penalize the infringer in some ways, the law allows you to receive the profits of the defendant that's attributable to the infringement that was not taken into account in actual damages. And so the remainder of the award in this case was a percentage of the profits of Mr. Williams and Mr. Thicke related to Blurred Lines. That's how you got to $7.3 million, $7.4 million. There's also a third component of damages in a copyright infringement case, and that's called statutory damages. And what statutory damages is, it's something set by Congress, because many times works are stolen, but the infringer doesn't make any money. It's not successful. And to penalize the infringer even where they don't make money, the law allows statutory damages for willful infringement up to $150,000. And the plaintiff can elect after the judgment whether they want the statutory damage award or the damage award that was plus the profits that were awarded. So obviously in this case we will elect the damage and profits because it far exceeds what the maximum is for statutory damages. But that component is there just to make sure that someone who doesn't make money still has to pay.
Excellent. All right. Thank you so much. Now let's get into lots of young lawyers. The legal industry as a whole has changed. We have a handful of lawyers that listen to our podcast show regularly. So I want to talk to you about your amazing career trajectory. First of all, in today's day and age, what does it take to become an entertainment lawyer and to get to where you are?
Well, to get a lot of hard work and taking advantage of opportunity and putting yourself out there and taking risks and just being a good person and have people like you. I mean, truly, I came out of nowhere because I met some people who liked me and who gave me a chance. And it's always good to have someone believe in you and to give you a chance. And then it's up to you to make the most of it. So this is no different than any other job or any other field or any other occupation. Hard work, dedication, loyalty to your clients, and being a good person. All that. And, the sky's the limit for anybody.
One thing I kept saying I was going to ask and I forgot to ask, but I'm not seeing anyone talk about that because it's really not an issue, but just for general understanding. T.I., Mr. Harris, Clifford Harris, was sued, but then he walks away with no real liability or legal liability. Could you explain to our audience why that is, for those who might have been curious about why the record label gets to walk away without any kind of legal liability?
Yeah, we're going to be filing a request to correct that part of it. The law is that everyone up and down the chain that distributes an infringing product is liable. There is no such thing as innocent infringement, whether you know about it, whether you know about it or not. So we actually had a discussion with the court about this, and the court invited us in the event that people who made a of the song, and T.I., the evidence was, came in later and added his rap section later, so he wasn't part of the original song with Mr. Thicke and Mr. Williams. But he is part owner of the composition, and Universal did distribute and sell the composition record. So they are ultimately jointly and severally liable, and we're going to ask the court to fix that. And we actually had a discussion with the court about what we would do to go about fixing that. But my feeling is the jury probably said, Pharrell Williams and Robin Thicke, you created the song, you did this, you're responsible, and didn't maybe understand that even though they're directly involved in creating it, they still are liable because they're selling the record that contains the infringing work. And we're going to, and they are jointly and severally law. So we're going to ask the court to fix that.
That's what I thought, because I kept looking at it saying, okay, that's interesting. And I know there's a recent lawsuit, if I remember, where Live Nation is been, hurled into court for something similar, where it's like you're still responsible for a copyright infringement affecting Jay-Z, because ultimately you distributed and did all those different things and promoted and marketed the infringing material, which I thought was just quite interesting. And so when I saw this, I kept saying, okay, where is T.I. in this process?
Ultimately, he should be. The law would make him jointly and severally liable, as is the record label. Like I said, ask the so that's where that goes.
We're looking at the language of the law, absolutely. Okay, so now let's get back to talking about you and getting into the legal industry. And you talked about how generally you be a good person, do the work, and all that. But you also have been at I would say, a visionary in cutting edge litigation. You handled the Eminem situation with digital downloads and licensing versus sales. Could you tell us a little bit about that, and then close out this interview with specifically talking about the current state of the music industry? Where is the current state of the industry?
The Eminem case, I won't be too long-winded on it, but in a recording agreement, there are generally two ways that an artist is paid. One, if the record label sells a record, they get a relatively small percentage of a retail price of the record. And why is it a relatively small percentage? Because the record label, with each unit they sell, they have to create the jewel case, they have to create the liner notes, they have to create the CD. So there's costs involved, and there's cost of distribution. But where the record label has traditionally licensed the master recording to a third party who does all the work, think of K-Tel Best Hits of the 70s, they call up Universal and they say, hey, we want to put one of your records on this compilation. In those cases, generally speaking, the recording agreement says that the record label will split profit, the money received, with the artist 50-50. Why? Because the record label has no costs in that situation. They just send the CD, digital file to the third party manufactures it, the third party distributes it, everything is basically found money. So when digital downloads came about, record labels took the position that they were selling the record, the download, to iTunes, who was reselling to the public just like a record store. And we felt like, no, it's a license. You're just sending a digital file over to iTunes, just like in the license scenario, and you should be paying 50% of your net receipts, not the lower record sale royalty. And so we litigated that, and we won. And that was obviously a landmark decision, and has spawned many other cases and many other settlements, and was a huge victory for us.
Okay, and then close it up with your own predictions and overview of where we're headed. There's current legislation in Congress with respect to copyright and re-examining our copyright statute, and there's a lot of changes in the industry. What is your perspective on the future and also current state of the music industry?
Well, I mean, it's always developing. It's always changing with modern technology. It's inevitable. Just when we litigated the Eminem digital download case, permanent downloads were the big thing. Now, 5 years later, it's all subscription models and advertising models and things like that. And how do the artists get their fair share of the advertising revenue and advances and money that may be coming in through different means? It's always developing, it's always changing, and there'll always be people who think that artists who believe they're not being paid appropriately. I have one client who negotiated a deal many years ago before YouTube, and this person's primary revenue source consists of DVDs and those kind of things. And now someone's putting all this stuff on YouTube, where you can get what they have for free. And so how does that work? How do they get paid? How is that allowable? And so all these issues are at the forefront today, and it's only going to get more complicated as technology develops. So Where it's going is hard to say. I will say this, that when people thought that was the end of the record business because people were pirating those downloads and the record company wasn't going to be able to make any money. But now, in today's day and age, the costs of the record label are far less than they ever were. You could have 3 people in a room just licensing content all day. You don't have the big manufacturers or distributors that are needed any longer. Record stores are pretty much gone. So it's a much more which has less costs involved. It's just a question of figuring out how to make the money. That's the challenge, to figure out how it should be paid appropriately. So it's changing, it's developing, it's very interesting.
You know what? You said something that I have to ask this final question, so I'm cheating. When you say it's going to get more complex and more complicated, how can lawyers like you, lawyers like myself, and lawyers generally in this field be prepared to meet this ever-evolving space and the legal issues that come out of it that are so complicated? How do we get prepared to meet the challenges in the 21st century and beyond?
The way we did in the 20th century and the 19th century and the 18th century. Be on top of the law and think creatively and always keep an open mind about ways to attack issues and ways to attack problems. It's the people who don't think inside the box that make sure that everything is handled appropriately and handled in the way it should be. So that you have to be creative in your thinking. That's always important.
Thank you so much. What a delight. It was good having you on, and thank you for shedding so much light on your case and your strategy, and also giving us insight on your legal career to inspire our young lawyers as well. It's been good. Thank you.
It's my pleasure. Thank you.
AML people, friends, guests, thank you so much for listening. Until our next episode, I will catch you all later. Do not forget to subscribe via iTunes, Stitcher Radio, or go directly on the website at www.africamusiclaw.com and sign up with whatever means is convenient for you. All right, catch you all later. Cheers, people.